Hi, I'm Charlie Roadman, Austin criminal defense attorney, and today I want to talk about the timeline of a criminal case, or what I'm calling the criminal justice journey. Okay, so we've got the timeline. It begins with the arrest and ends with the resolution of the case. And by resolution, I mean some sort of plea, dismissal, jury trial, verdict, or something just where it ends. Now, of course, if you're on probation, the case kind of keeps going past that, but resolution is the disposition of the case. So basically, you've got the arrest, and then you're released from jail, and then you hire an attorney or get an attorney somehow. Now, it's very important, and I mentioned this, is you got to follow all the bond conditions and stay out of trouble during this timeline. That is rule number one. Okay. Now, you've got court dates that are going to be periodic throughout this. Okay, so, and basically it's usually once a month. I mean, it can be a little longer than that or shorter, but these are sort of check-in periods where the judge is making sure things are moving along so that there is a resolution. Now, the first part of any sort of criminal case is the administrative part. And, you know, the court has to create, documents and assign you to a court and let the judge know, and the clerk has to create a file, and the county attorney or district attorney has to create a file. They have paperwork, indictments, various other things that have to happen because you're being charged with a crime. It doesn't just happen, you know, everything's not done the moment you are in jail. There's sometimes months, sometimes 6 months of paperwork that has to be done in this phase. So nothing really can happen on your case while the administrative part is going. Now, at some point, they're going to start releasing evidence to your defense attorney. Now, that could be videos or offense reports or witness statements. There's all sorts of things that has to be given to your defense attorney before a result of the case can even be talked about. Okay, so it sometimes takes a long time, and in particular d.w.i. like the blood results may take 6 or 8 months to return. And without the evidence, the defense attorney can't really resolve the case. It would be malpractice to resolve the case without the evidence, right? So, and the prosecutor doesn't want to talk about it because they don't know what the facts are yet. So, as the evidence is released to the defense, and the prosecutors also get it slowly. Now, that's when the negotiations with the prosecutor can really start. Once the main pieces of evidence have been distributed, essentially. Now, I add a little extra because sometimes the defense attorney finds an offense report that mentions a video, or a video that mentions some other audio, and we go to the prosecutor and go, hey, what's this? And then they go look at it and get it for us, or we get it ourselves or something. But during the negotiation, there is also evidence that is sort of discovered. Now, at that point is when there's a deal or no deal. Once the negotiations have reached a point where the defendant either accepts a plea bargain or rejects it, okay, or there's some sort of suppression hearing or some sort of legal battle over evidence. So at this next phase, if there's a deal, if there's a plea bargain, or even, and a dismissal is also a type of plea bargain, then there's paperwork done. Okay, now if there's no deal and we set it for trial, then this is the period where we prepare for the trial. Or, like I said, suppression hearing, we prepare to argue about the legality of some of the evidence. Now, during this first half of it, what a defendant needs to do is follow all the advice of their attorney, okay, and start to build with their attorney a good guy packet or a good gal packet. And that is basically documentation that shows what you've accomplished during the time, whether it's classes or work related, or just basically as much good stuff about you that can be documented is what you want to get to your attorney. So that when they're negotiating with the prosecutor has an idea of who you are that isn't just limited to the offense report. Okay, so from the moment you hire an attorney, you guys start working on putting together a good guy, good gal packet. Now, during the negotiations, you're still going to be doing stuff. Whatever your attorney says, hey, you should do this. The prosecutor's, he's concerned about that. You should do this. You know, so basically you just, throughout this whole process, you're going to be doing things that help your attorney negotiate the best possible result. Now, of course, there's always a chance that we can't get what you want or the defendant wants, but this is the best attempt to try to get a good result, okay, a good negotiation. So that is the basic structure, and I wanted to talk about that because there's a lot of criticism sometimes of defense attorneys from clients. They say, well, the defense attorney was just dragging it out, and I say, it's not the defense attorney usually dragging it out. It's just the process. The process takes a long time, and we're not in control of it. So I just wanted to give a basic overview of the basic periods, and if you have any questions, give us a call, and best of luck.